Lawyers for the disgraced, twice impeached, 4 times indicted ex-president have taken one final step before an appeals court. Here's arguments on what is a fundamental and potentially existential question for our democracy. Can presidents be tried for things they did while in office? Team Trump has filed a brief in support of their push to toss out the federal election interference case, citing the doctrine of presidential immunity. It is chock full of claims that we are likely to hear in court next week and on the campaign trail as Donald Trump makes a third bid for the White House and as the first votes are to be cast in Iowa in just under 2 weeks. Trump's lawyers says that, quote, the 234-year unbroken tradition of not prosecuting presidents for official acts, despite vociferous calls to do so from across the political spectrum, provides powerful evidence. Presidential immunity exists, of course. No president prior to Donald Trump tried to disrupt the peaceful transfer of power. Trump's attorneys also point to the, quote, likelihood of mushrooming politically motivated prosecutions and future cycles of recrimination. As if the ex-president isn't the one who is promising retribution against his political allies, and his allies aren't the ones plotting to end the independence of the Justice Department. The most audacious argument in here, however, one that we discussed on this program yesterday. Donald Trump cannot be tried in a criminal court for his role in the January 6th insurrection because he was acquitted by the Senate during his second impeachment trial. The New York Times reports both legal experts and some of the senators who acquitted Mr. Trump have disagreed with that position, not least because the federal charges he is facing are not analogous to those he faced during his impeachment. And that is where we start today with national investigative reporter for The Washington Post, Kara Lenning, plus former lead investigator for the January 6th Select Committee, Tim Heaphy, is here. And with me at the table, former acting assistant attorney general for national security at the Department of Justice and co-host of the MSNBC podcast Prosecuting Donald Trump, Mary McCord. Tim, let me start with you. What do you make of the arguments Trump's lawyers are making here?
They're making the same arguments, Alicia, again and again and again. They're the same arguments that Mark Meadows has made in Georgia. They're the same arguments that witnesses made when faced with select committee subpoenas, which is everything that happened was connected to the official business of the White House. And that's just not accurate. Again, not everything a president does, not everything a White House chief of staff does is part and parcel of their official responsibility. There's a clear line between what's official, the conduct of foreign policy or domestic affairs, the things clearly within the range of a president's official responsibility, and things that are outside of that range. And that's the question before the Supreme Court. Is what is alleged part and parcel of the president's official responsibility? There's really nothing in this new pleading, which is just a reply to Jack Smith's pleading that was filed earlier this week, that sheds light on that question beyond what we've heard already.
Right. Carol, to Tim's point about the fact that we've heard this before, one of the people we've also heard it from is Donald Trump on the trail. That is not an accident. Carol.
Oh, I'm sorry. I thought your question was for Mary. Can you say it one more time, please?
Yeah, absolutely. I was saying that of the people we have heard these arguments from before, one of them is Donald Trump himself. We've heard it on the trail from Donald Trump, him trying to make this argument against presidential immunity.
That's right. And it's an important drumbeat for him to keep hitting over and over again on the campaign trail, because saying that he is being persecuted, that he is the victim of a politically tainted prosecution, which is essentially hinted at and alleged in this new pleading, that he is a victim is incredibly valuable to him as he campaigns and tells his supporters that Democrats in control of the Department of Justice, Democrats in control of the White House are trying to block him from becoming their next president and trying to block their will, their wishes. That is probably one of the most important points that Donald Trump will make over and over again on the campaign trail, with quite a lot of success in the polls, as we've seen ever since he was actually charged with crimes in the effort to block the peaceful transfer of power. The first time a president has ever tried to do that. Ever since he was charged, his poll numbers have actually been inching upward fairly steadily.
So, Mary, if you are Jack Smith's team, how do you then prepare to rebut these arguments?
Well, he rebutted them, of course, in the filing he put in with the court on Saturday, which is that the founders could never have possibly imagined that a president would be immune from committing crimes that were directed at, overriding the will of the people and staying in office when you're not elected. Jack Smith points to the text of the Constitution, of course, which doesn't include presidential immunity. He points to history, which doesn't include ever an instance in a criminal case of there being presidential immunity. And he points to the structure of our system, right, of separation of powers and how it really would defy that. We also see some important amicus briefs that were filed in support of Jack Smith's position in this case, one by a number of former Republican high-level administration officials and judges from 5 different Republican administrations raising the executive vesting clause argument, which is that it would violate the executive vesting clause, which vests the power of the presidency in one person for 4 years and 4 years only unless reelected, and to allow a president to escape criminal liability when they commit crimes that would keep them in power past their 4 years when they haven't been elected would violate directly that constitutional provision. Another similar amicus brief from another group of mostly conservative lawyers makes similar arguments. So there is going to be a lot before the D.C. Circuit Court of Appeals, including, in addition, another amicus brief that argues this shouldn't even be able to be appealed until the end of trial. So there's a lot here for the court to chew on, but Jack Smith has stuck with the same arguments he's been making all along.
Do you think, though, if you are Team Trump, that this is about delay, or do you think you actually believe you have a shot of getting this tossed?
So I think there are 3 things he's trying to do with this appeal. One is he is hoping that eventually, if he loses in the D.C. Circuit and can get the Supreme Court to accept this case, he's hoping that he will pull enough justices to say there should be presidential immunity and will agree with him that what he was doing was within the scope of his official act. So I think he legitimately wants that, because then the case is over. It is done. That is for all the marbles. But in the meantime, he wants to delay. As you know, the trial proceedings have been stayed. The judge hasn't officially moved the March 4th date, but nothing is happening right now other than Jack Smith filing things that are going unresponded to. Jack Smith did ask in his brief in the D.C. Circuit that whatever the D.C. Circuit does, that it issue its mandate within 5 days of its ruling. And what a mandate is basically a directive saying this case is now going back to the lower court. That means the loser, whoever it is, if they want to seek cert, they really need to be able to move before that mandate issues. Otherwise, the stay will lift, because once it goes back to the lower court, the stay would lift. And if Donald Trump loses, let's assume the D.C. Circuit rules there's no such presidential immunity, he will want that stay in place. So it will constrict the time unless the Supreme Court gives him more time, or unless the D.C. Circuit denies that request, which they might. It would restrict the amount of time that he has to sit on things and further delay them.
Carol Leonnig, to the extent that delay is part of the strategy here, not just from the legal team, but from Trump's political team, how confident are they in that strategy?
I think that they're trying to appear bullish, but privately are not so sure this is going to work. I mean, it's really hard to, with a square jaw and a straight face, claim that the former president's acquittal in an impeachment is anything akin to the charges that Jack Smith has brought. That's one of those claims that you all have talked about very carefully and considerably, but I would just say that it must be very difficult in that legal circle for people to believe that that spaghetti on the wall is going to work. It's true, I have to say, that one of the strongest things in Donald Trump's favor, and which his lawyers have privately discussed, is the notion that this is untested law, right? We have never seen a former president charged with a crime. Yet we, as you have said very well, Alicia, we have never seen a president try to hold on to power and refuse to accept the free and fair election results. We also haven't seen a president be the ringleader, as Tim Hafey's investigative committee so well laid out. We've never seen a president be the ringleader for all of this marionetting of individuals trying different ways, different legal strategies to toss free and fair election results into chaos, into question, into suspicion, to try to first threaten his own Department of Justice if they didn't say there was fraud where there was none. Next, to get states to block the election results and also call those into question. And then finally, the Hail Mary pass to pressure and bully a vice president into refusing to certify those elections in the pro forma January 6th certification.